just before you zoom, can I just apologise to everybody about how cold the court is? I don't know if everyone was freezing before the short interment, or perhaps it's just up here that it's freezing.
I'm delighted.
Yes.
No apology required.
Well, for those that aren't in robes, we have asked for them to try and make it a little warmer without sending everyone to sleep, but I'm not holding my breath. Yes, now.
A little over lunch homework.
Yes.
My Lord's quite right. There is no provision equivalent to Section 1 and 2 in relation to the handbook in the Health Act 2009. What there is the slightly elliptical Section 5 that simply requires the Secretary of State to ensure that the handbook continues to be available to patients, staff and members of the public, and that at least once every 3 years it's reviewed, the first review not later than the 5th of July 2012, and thereafter it must be published. Of course, the status of the handbook is in part led by the contents of the Constitution itself, and I can make that point good by the version at tab 3 of the supplementary bundle. The Constitution itself refers to the handbook at page 66, bottom right-hand corner, page 2, top left-hand corner. But more particularly than that, when one comes to the patient access rights at page 68, bottom right corner, 6, top left corner, you see the big red box itself says that the rights are summarised in the Constitution, this Constitution, and explained in more detail in the handbook to the NHS Constitution, which also explains what you can do if you've not received what is rightfully yours. But the point then goes beyond that, because of the 6 rights in this particular section adumbrated therein, it's only the 6th one with which we're concerned that makes an express reference to the fact that the waiting times are described in the handbook to the Constitution. And so we say, at least in respect of this right, there's an extensive incorporation by reference. And then the last point I should make, really to further that, is at 78 of this bundle, page 6 of the handbook. There's an explanation of the underpinning that the Constitution has, and that points one to the Health Act 2009. And then this, which I had missed beforehand, that my lords might think it's relevant. How has the Constitution changed? This is, of course, the March 2012 version. A consultation proposing the inclusion of new rights in the NHS Constitution was held between November 2009 and February 2010. Following that consultation, a new right to waiting times will come into effect in April 2010. The handbook has been amended to explain what the new right to waiting times means. So behind the 2010 directions, there was plainly a dedicated consultation, effectively as to whether or not it should be upgraded from a pledge to a right, as in fact happened. And I regret to say I don't have any further details about what that consultation entailed, what the consultation paper was, the consultation questions, the response to consultation, etc. No doubt if we find it, we can supply it to the court and the court will make of it what it will. So that's the first question I was asked. The second question my Lord Justice Popplewell asked me was in relation to the rationale or potential rationale for the differences between Regulation 45 and 47 to 48. And I explained that it was my understanding that there was a duty of publication in relation to consultant-led services. And I'm relieved to see that I'm, I think, broadly right in relation to that. And perhaps the best and easiest place to see it is from the full version of the 2012 regulations in tab 2 of the supplementary bundle. This is the topic of part 8 of the standing rules, and it corresponds to other rights in other sections of the NHS Constitution, because we've looked at access to treatment. There are NHS Constitution rights relating to patient choice and matters of that kind, which are implemented by these provisions. So the 6 rights I've been showing you are not the totality of the rights in question. And you can see this is about choice of health service provider. And the duty of choice is contained in Regulation 39. It's in 2 parts. 39(1) and 2 applies in relation to consultant-led treatment. So you need to have a person requiring an elective referral for whom the body is responsible. That triggers the choice in sub-regulation 2. And the choices specified for the purposes of this paragraph are the choice in respect of the first outpatient appointment with a consultant or a member of the consultant's team of any clinically appropriate health provider, etc., etc. That's the first right. The second right in 3 and 4 is in relation to elective referrals for mental health services and provides for a different but equivalent right to choose between different providers. Now, that patient choice right, therefore, is only in relation to consultant treatment for non-mental health services, and it's then fortified by the duty to publicise and promote information about choice in Regulation 42, page 35. A relevant body must, here's something familiar, must make arrangements to ensure that. So exactly the same language as our Regulation 45. The availability of choice under the arrangements it makes pursuant to Regulation 39 are published and promoted. Without prejudice to the generality of paragraph 1, those arrangements must include arrangements for publicising and promoting awareness of information about 1. Health service providers for enabling a health service provider to be chosen in accordance with Regulation 39(1), consultant-led teams for 39(1), and mental health teams for 39(3). And you then have to go on to publicise details and promote awareness of where that information may be found. And my understanding of these provisions is it does effectively condescend to issues like success rates on particular operations, fatality rates on particular operations, if that's an outcome, and matters of that kind. And you use those metrics about a consultant-led team to choose which consultant it is you want to have to treat you. And that is part and parcel of the competition rationale that drove a lot of the 2012 reforms, which was that patients should be making choices, and those choices should be driving a market, effectively, that rewarded the best performing entities within that market. That's how that was meant to work. Now, against that backdrop, we do say it makes sense that the Regulation 47 and 48 duty is confined to consultants, because that may be where you think, for instance, questions of patient choice are particularly acute. So, I hope I've sufficiently expanded the instinctive answer I gave to make it at least have the appearance of sense. Then, my Lord Justice Popplewell raised the question as to whether or not there was effectively a spectrum of duty with a kind of classic Section 1 target duty at one end of the spectrum, and then various different linguistic formulations arriving at various different shades in between. And it suggested to me that, for instance, if it was a duty to make arrangements with a view to ensuring that, that would be at one end of the spectrum, whereas must ensure would be at the other end of the spectrum. And of course, one of the things the court has to decide is whether or not the formulation effectively chosen by Mr. Justice Chamberlain is insufficiently rigorous, even within that spectrum. Because the bottom line is, the formulation he has chosen is one in which a recurrent failure to meet the metric, let's not call it a breach because that's questionable judging, a recurrent failure to meet the 92% 18-week metric has been in place for 7.5 years. It's been in place since March 2016 is the evidence. I think it's in 25 of our skeleton argument. And that's the eventual question at the end of the day. Is the content of the duty so devoid of substance at the end of the day that a breach of that duration, which must be persisting notwithstanding COVID and all the types of exceptional circumstances my Lord put to me about doctors' strikes, etc., is so devoid of content that it doesn't respond to a breach of even that protracted nature. And in our view, if that is the eventual result, what in substance has occurred is that which was meant to be elevated from a pledge to a right was never a right at all. It was never no more than a pledge in the first place. And effectively, the contents of the NHS constitution and everything that go with it are a misdirection because there is nothing of substance. If it can't respond to even a failure to meet the metric of that protracted nature, it's not a duty of anything other than the vaguest target nature. And there we are. Then lastly, I think I should very briefly address the Tandy case, which I was referred to by my lord, and forgive me for not getting to it previously. The Tandy case concerned Section 298 of the Education Act 1993. And if my lord, my lady have the report, you'll see the relevant provision set out at page 718 in the speech of Lord Justice Staunton in the Court of Appeal. The critical thing to note was that the apparently open-ended target duty in 2981 was then effectively given further teeth by subsection 7, because subsection 7 said, in this section, suitable education in relation to any child or young person means efficient education suitable to his age, ability, aptitude, and to any special educational needs he may have. And what that meant was when you put the two provisions together, there was an obligation to tailor by reference to the particular needs of a particular child. And that being so, Lord Brown-Wilkinson, in the passage that you referred us to, said, well, this is on any view an individual duty. It's not a target duty of an open-ended nature, and really that's the end of the matter. And on that basis, he effectively distinguished the earlier case, the case of Barry, about which there had been so much argument in the Court of Appeal. I don't think that there's anything that one can safely obtain from this case by way of general proposition, because all it shows at the end of the day is you have to carefully construe the relevant provision. You have to put it in its context. And of course, individual targeting or an individual specific circumstance responsive duty is not a target duty. But we say, by exact parity of reasoning, a duty that contains an end obligation of carefully metricized, cohort-based result attracts exactly the same analysis. And I go back to the example I gave, the post office example. A public law duty on the post office to make sure that 92% of letters are delivered in a certain period of time to be assessed by a very carefully tabulated scheme of rules to ensure consistency of counting in different post offices is an obligation of such result, as is the obligation here. It's meant to provide to the users of that public service a guarantee of the underlying quality of the service that they receive. And it's no less a concrete a duty that they can't point to the fact that they have received deficient service and therefore can bring a claim in damages or something of that kind. So we think Tandy doesn't really take matters much further, nor does the exercise my learned friend has engaged in, and I could pick this up in reply, casting around in authorities where the words make arrangements appear, like the Reliance case, and saying, aha, you only have to look at the statutory duty in Reliance to see how very different it is to the statutory duty at play here. So what we're left with is our core submission.
Sorry, just before we leave Tandy, I understand everything you say about it not necessarily having any bearing on our case, but something that was in my mind was how it affects how one might identify the ratio or the important reasoning in Ali. Because that was a case in which the Section 8 said must provide, or something along those lines, pretty firm words, suitable education. No schooling at all was provided for the 300 or 400 or 500 or however many it was people in the East London area. So there wasn't any room for doubt about whether it was suitable or not. And one might have thought, certainly in the light of Tandy, that there's not very much difference between an obligation to provide schooling to the 500 individuals who want to go to school in an area and the obligation to provide full or part-time education to this subset of children who, by reason of illness, exclusion, and so on, aren't in the main system. And it may be, therefore, that the language that really that one finds in Ali, which identifies why one can reconcile the difference in the two decisions, is not so much the language of it being something evaluative, but those passages we find in Ali which focus on the fact that in the circumstances of that case, this was an obligation which the local authority could find itself unable to fulfill in circumstances which it could not anticipate. And that may have been one of the driving factors for dealing with, for identifying it as a target duty in that case, which doesn't run over into this case. It's just trying to reconcile the two actual decisions, and I quite understand that Ali wasn't apparently dealt with here, and that whether one can or can't reconcile them may not have a direct bearing on the result in this case. But that was what was particularly interesting to me about this. It's what it might tell us about the ratio of.
I understand my Lord's point, and of course the family planning case shows that even with a genuine target duty, you may have facts sufficiently stark that even then you can say that the relevant target duty has been breached because the relevant entity hasn't even tried to provide the service. So even within the target duty box, there will be cases where the facts are so marked and so extreme that the breach has nevertheless occurred. Of course, in Ali, at page 836 and following, there's an extensive analysis of the sort of discretionary factors in the case, and they fail in that case. But in terms of how the court parses the duty and what it says is the distinctive characteristic of a target duty, it is the need to make value judgments that they identify explicitly. And that, of course, tallies with the contents of section 8.1 of the 44 Act, back at page 826. Because although you have the prefatory wordings of the conditions A and B, you then have the further lengthy conclusionary paragraph saying, and the schools available for an area shall not be deemed sufficient unless, and then there's a whole set of multifactorial considerations, so a respondent would put it, that have to be taken into account in deciding whether or not what is provided is sufficient. And that, I think, that is the context for Lord Justice Wolfe's view that this was effectively an evaluative duty.
Well, I understand you say that, but subsection 7 in Tandy also had a huge evaluative element in deciding what suitable education is in relation to a person who falls within the category. Now, what I had in mind in Ali is the passage at 829, just below F. The duty under section 8 is therefore not absolute. A local education authority which is faced with a situation where, without any fault on its part, it's not complied with the standard which the section sets for a limited period, is not automatically in breach of the section.
Yes, there is definitely a whiff of what my Lord is suggesting there. But I would suggest that the words sets for a limited period is also germane, because the period of non-compliance in the Ali case was, certainly compared to the facts that back into this case, a relatively modest one.
Well, I'm not sure.
Well, I think
you're able to make that submission on the facts of this case. The investigation as to whether there has been compliance with a target duty, perhaps I'm making a point that doesn't meet yours, or I ignore it.
Well, there we have it. I think there are two exercises. Exercise 1 is working out whether or not it's a target duty or not. If it's not a target duty, it's obviously a stricter metric to assess compliance. Exercise 2, in relation to which I should emphasise we don't have permission to appeal, and it's a separate issue, is whether even if it's a target duty, the target duty has been breached. And as I understand it, there was extensive argument on that subject below. Is that right? So that issue is not before the court. But obviously, if we win on the upstream issue, it falsifies the judge's conclusions as to whether or not the facts in question satisfied the more onerous breach that we urge upon the court.
I'm sorry for taking so much time on that.
I just wanted to conclude
very helpful, thank you.
With this last remark, which is this. I've made the point, both by reference to the 2010 directions and handbook and the references to the obligations being suspended. And I've made the point in answer to my Lord Justice Popplewell's question that in circumstances of impossibility of compliance, the proper response is to suspend or amend the relevant provisions. And the real problem is this: if you legislate in a way that provides just about every indicia that you intend to create a concrete and legally enforceable right, the real danger is that unless the court holds the legislature to the meaning and consequences of what they do, the legislature or the executive is released from doing that which may be both legally and, more importantly, politically unpalatable to do. Namely to say, in fact, it's proved impossible to operate a right to waiting lists. We must downgrade it to a pledge. That's the best we can actually practically do. Doing that reflects the reality of what is practically and legally deliverable. But of course, it brings with it a very considerable political cost, because then the government of the day has to take the hit for saying, we can't do these things we promised we'd do. And that's really the danger in my submission of a submission, however attractively put, that resources and practical concerns and strikes and COVID, etc., release us from complying with these obligations. The government should be fronting up and saying, actually, we need to change the law because the law, as we made it, is not properly operable. Great.
Thank you very much. Yes, Ms. Craig.
My lady, with regards to the main point under appeal, I'd like to make a few points about resources and capacity, about the nature of the commissioning function of NHS England and ICBs. I'd like to turn to the handbook and the NHS Constitution before turning to the nature of target duties and the remedies sought by my learned friend in this case. If I could start with the issue of resources and capacity. The factual background is set out well in the judgment below, and it's not an issue between us. And so, in my submission, the starting point in this case is unusual in that it's an appeal which seeks to persuade the court to find that NHS England is acting unlawfully in meeting or failing to meet what is said to be a hard-edged standard or target that it and the wider NHS is making all reasonable efforts to meet. That was the finding below, and that's not under challenge. This is an unusual case because this isn't a public interest litigation which shines a light on neglected areas of policy and ensures by the clarification of legal duties that obligations are brought to the fore. Rather, we would say that the issues before the court are already subject to public and political scrutiny and receiving daily attention at the highest level. It's obviously not in dispute that the 92% standard is not being met, and I'll use the term standard to avoid issues of breach or metrics and so on. And my lady has seen the figures, and they're at paragraph 31 of the judgment below. All the raw data is at page 119 of the supplementary bundle. I won't take the court to it now. It's there for your note should you wish to see it, but that's the basis upon which the figures are collected in that table, I think, on a yearly basis. Now, the court observed that the impact of the pandemic was obviously a major driver, although it's obviously right to note that the slippage, although limited, started in 2020, apparent from those figures. And I've already said that there are concerted efforts to address that, which are a matter of the highest political and organisational prominence efforts. but the problems relating to what I would describe as capacity in the system, to issues such as workforce, numbers and retention, and now, in particular, since the judgment below, the impact of strikes are real. And I make those points not as jury appeals, but because they highlight in my submission how the delivery of the standards is not in the hands of the commissioners. It lies first and most directly in the hands of the bodies that are contracted to deliver a service, but which too have to contend with matters which may be outside of their control. Now, the answer to these difficulties given by my learned friend are either the suspension or abrogation of the regulations, which he says would be more politically honest in effect, or more resources. And it's true that in 2010 there was a reference to suspending the directions if there was an influenza pandemic, and my lady has seen that, I think, in the copy of the 2010 handbook. But I would just note as a footback note to that suggestion that suspensions are a good idea or possible, the provision of Regulation 6E8 of the founding Act, the 26th NHS Act, which is tab 1 of the bundle. The court has been shown, of course, Regulation 6E, which is the power to make regulations requiring services.
So this is Section 6, is it?
It's Section 6. I'm so sorry, I said Regulation 6. I do apologise. Section 6E in the 2006 Act. We've looked at this already, and in particular, from my perspective to observe as we go along, I would agree that the relevant provision here in relation to the founding inquiries of these regulations is Regulation 6, Section 6E2A, which requires NHS England or ICBs to arrange for specified treatments in a specified manner or within a specified period, rather than B, which relates more directly to things like the availability of services, including, say, nurse treatments. But if we turn over the page, the court will see at subsection 8 that the regulations may not impose a requirement on only one integrated care board. And obviously, one would include plural ones. The point is you have to regulate for all of them. And what you can't do is create a system by regulation of derogations which dip in and out with some sort of provision being made on a month-by-month basis for those trusts or those ICB services which have found themselves in a little local difficulty for a while. So it's all or nothing, suspension or continued application. So I'll come back, if I may, to the question of suspension in relation to remedies. But the key thrust of Moylan Friend's submissions was that this is a question of resources, and that the honest thing to do is to provide more resources, and that may be what is required and what was mandated by the 2012 regulations. I would just respectfully wish to remind the court that it's perhaps worth remembering that the history of this case, which was in relation to gender dysphoria and gender identity services, was not one in which resources or the failure to allocate resources lay at the heart of the problem.
Well, financial resources.
There
are other resource problems.
There are other resource problems, but they are problems of capacity which cannot readily be overcome.
By capacity, that you include absence of qualified personnel.
And that includes the willingness of qualified personnel to step into this gap. And my lady has seen, I'm sure, the findings both at paragraph 101, but also paragraph 114, I think, of the judgment below, which do make the point that the court was alive to the fact that this was not a simple question of simply coming up with more money to deal with these problems. So, my lady, the court has the evidence of Mr. Glyde in the supplementary bundle, which was the underlying evidence. But it was at paragraph 101 of the judgment that the learned judge below made his findings on the nature of the problems, the current long waiting times, the increase in demand, clinical controversy, the difficulties of recruiting and retaining sufficient clinical specialists, and the need to redesign the commissioning model. And then, despite observing that it may be that NHS England was too slow to respond, concrete steps were being taken. So those are not problems, I would respectfully submit, that are simply amenable to description as being a problem of resources. And that appears also at paragraph 114, where the court makes the point that the claimant's submissions overlook the evidence of the cause of these problems as the lack of specialist clinical capacity, and that efforts are being made to develop that. And I would respectfully submit that many of the same issues do reappear in relation to the problems of pandemic recovery. It's not a simple question of the allocation of resources, it's a question also of the capacity of the system and the need to redesign matters to increase the throughput again. Further, at the risk of giving evidence, we as commissioners, that is as NHS England, have a restricted budget. I think that's probably uncontroversial. We have what is allocated to us on an annual basis by the Secretary of State, but which is also tied. There's an NHS mandate every year which achieves a high degree of control. Still less, and this is apparent from the judgment below, can we direct more money towards NHS England's specialised commissioning at the expense of the ICB's commissioning, which of course are under the same obligations in relation to the Reg 45 duties as we are. And that was the point being made by the judge at paragraph 97 of his judgment, when that was, I think it was subject to criticism by a learned friend, that he was describing there the submission that the solution to the problem was to retain more money at the central level at NHS England, but it would have been at the expense of the ICBs. So we're not in control of the size of the pot, and its use is carefully controlled. And I make these points, my lady, because in my respectful submission, they do sit with some considerable importance behind the obligation to make arrangements to ensure that the requisite standard is met. Now, the judge below, of course, held that this meant making arrangements with a view to securing compliance with the 18-week standard. And we also know that ensure, the word ensure, is capable of bearing a range of meanings. Now, the court has in the bundle the case of Vasey, tab 4, which I fully accept is merely an illustration of that principle. But, and equally where I also accept the learned point made by the learned friend, that in effect one has to come down to what the words mean in the context of these regulations. But nevertheless, it's worth reminding oneself in my respectful submission that as the court observed very briefly, it's page 373 of the judgment, tab 4, that in that context, which was that of a building society which had to take reasonable care to ensure that the price is the best price which can be reasonably obtained, the court held that I think it's used, that is the word ensure, in the common and colloquial sense in which making sure is used. That is, as equivalent to ascertaining or satisfying oneself, and doesn't mean anything in the nature of warranty or a guarantee. So that's an illustration, and there's another illustration in a different context in the bundle at tab 17, the case of adult catering, which I won't turn to because it simply illustrates that in a situation where there was more control, the word was used, court held, in more of a situation of guarantee. So the word takes its meaning from its context, but in my submission, the words owe a lot to the fact, or the words chosen owe a lot to the nature of the commissioning duty and the extent to which the commissioners control the impact of the arrangements that they are required to make to ensure the intended result. Now,
I think Miss Gray, you referred to the case as Vasey, which of course was the judge, not the name of the
I
case.
did, didn't I? I'm so sorry.
My lady, the relevant provision, to save me having to come back to it, which is in dispute, is set out in the footnote at page 363. That contains the language. Relevant provision.
I'm so sorry. This is the problem of relying on a note, which sometimes typed at speed. I apologise to the court. The point is, however, a simple one. We can go through, as my learned friend castigates me for doing, the authorities and find words taking a different meaning in different contexts. But it's worth remembering that the word ensure does not necessarily import a clear and unqualified obligation to guarantee a particular result, as opposed to make sure or aim to secure as best as one can. Sorry.
Well, speaking for myself, I have a little difficulty with that, if one's focusing on the word ensure. But what one can say, both in this case and in our case, is that the words that you are to do something to achieve or to ensure,
make arrangements to ensure,
have an ambiguity arising out of the word to, which in common parlance, just like the Latin ut, may mean with a view to, or so as to achieve the result that. And it's the word to
yes,
that is capable of bearing either meaning, and that's where you look to the context. Speaking for myself, I'm not sure there's much room for doubt as to what ensure means.
Well, my lord, I'm very happy to accept that the better point is that, as your lordship earlier identified, that there is potentially a range of spectrum of language that one could have used here. On the one hand, we don't have clear language that says make reasonable efforts or make reasonable attempts to make arrangements to ensure, which would be one very easy answer, but neither do we have a simpliciter reference to ensure. What we have is something in the middle, make arrangements to ensure, and the challenge for the court is to give that its proper construction. And what I've been attempting to suggest, partly by introducing the topic of resources and pointing out that this case did not in fact start as a simple case of failure to attribute sufficient funding to a problem, is the nature of the commissioning function that we undertake. Here, we would respectfully submit that whilst the outcome, that is, making arrangements to ensure a particular standard has been specified, in the sense that the standard has been specified, there is, we would respectfully suggest, a broad discretion on how to attain that end, and choices to be made along the way in terms of priorities as part of our commissioning exercise. Measures relating to safety and quality, or measures relating to safety and quality, have to be wrapped up in the commissioning contract, and the consequences of the choices made in that commissioning decision will not always be foreseeable. So we commission services looking at all of the relevant factors, and although the achievement of the targets, standards, will be an element of the contract, it's specified in the contract, that's the most direct way of making arrangements to ensure the outcome, and an important one, the interrelationship between all those factors won't always be readily predictable, such as, for example, the trade-off between pushing more patients through at a rapid speed and meeting quality standards. So there may be, we would respectfully submit, inherent in the commissioning decisions that we have to make, a process of monitoring and reacting to systemic problems in particular and amendments. And that all flows from the commissioning function, and we would respectfully submit is reflective of the language of making arrangements. And I've referred, of course, already to the fact that, the duty, the achievement of the duty, is one that can't directly be secured by the NHS England or the ICB, because we are commissioning organisations, not direct providers. Ultimately, we're dependent on others to comply or deliver the arrangements. We're not in direct control of delivery. We can make arrangements with the aim that that's actually the limit of our powers and we can't deliver. And so in my respectful submission, the qualification or the construction placed on this obligation by the court below is an accurate reflection of the mechanisms for delivery and the nature of our commissioning powers. And it goes with the grain of both the Act, functions and the regulations. The make arrangements to ensure, in other words, reflects the reality and the relative limits of our control and the need to react when problems occur. So, my lady, this leads to the point that my learned friend, in making his submissions, has spoken repeatedly of a very loose target duty or a vague duty that the construction placed by the court on the duty by the court below has rendered it toothless or has denatured it in some way. That, in my respectful submission, is not a fair characterisation of the actual processes that are in play here. I've already made the point about political attention and the prominence of the targets, but that's reflected in the fact that the figures for adherence to them, to the standards, are published monthly, and there is guidance on the reviews that are needed if there's a falling short. We haven't looked at it, my lady. It's at tab 24 of the bundle, and one doesn't need to spend much time on it, but it's guidance of January 2012, issued by the Department of Health.
So this is the supplementary one?
No, it's the main bundle. It's tab 24 of the main bundle.
Authorities.
Authorities bundle, yes.
Referral to treatment consultant-led waiting times.
Yes. Reviewing the pathways of patients who've waited longer than 18 weeks before starting their treatment. And then it sets out, let's say January 2012, so it's part of the same suite of documents I would respectfully submit that are part of the genesis of all of these rights. And one can see under the heading of description on the first page, page 65 of the bundle, the references to the NHS operating framework, which was the source of the rights at that point, and the NHS constitution. Commissioners need to understand and act upon the reasons for unnecessary waits over 18 weeks. This guidance suggests methods for reviewing and reporting waits longer than 18 weeks in order to understand the causes and drive further improvements in patient experience. And then, I don't want to spend time reading the guidance that's sidelined at page 3, but essentially, paragraph 4 encapsulates it. Reviewing waits longer than 18 weeks will identify systemic problems which need to be rectified in order to deliver the universal right. Ultimately, when no unnecessary waits are being reported, it will confirm that all waits longer than 18 weeks are for legitimate reasons.
Could you read paragraph?
And then paragraph 6.
Para 2 as well.
I'm sorry.
Para 2.
I'm being asked to read paragraph 2. Universal right, set out in the NHS constitution and the NHS operating framework, should be delivered for every patient, unless the patient chooses otherwise. The tolerances are for patients who choose to wait longer or for whom this is clinically appropriate. And that's entirely right. The 8% tolerances, as they now are, I think it was slightly different back in 2012, are all about the legitimate reasons why a patient might not be treated within 18 weeks, rather than a mechanism that allows a degree of tolerance for slippage for reasons other than that. So there's no real grace in the regulations in the 8%. The tolerances envisage the reasons for being outside of the 18 weeks will be, in a sense, for legitimate reasons. But paragraph 6, the overarching aim of views of waits longer.
Sorry, just so the target duty,
yes,
as you submitted, is a duty to achieve 100%.
No,
a duty to seek to achieve 100%.
No, the target duty remains to achieve 92%. That's entirely right. The tolerance of 8%, however, reflects the fact that there will be legitimate reasons for not reaching the
In relation to the other 8%?
Well, actually, I'm so sorry. I wonder if I put that correctly, because, of course, if there's a legitimate reason, the clock should stop running.
Yes, yes,
So I'm wrong about that. I apologise. I've
Yep.
led astray by trying to respond to my learned friend's point. The legitimate reason should be reflected in the clock stop. So that shouldn't be the case. I'm sorry.
Which is what puzzled me about this a little.
Yes.
Because this does seem to be saying that the 90 and 95% were the previous figures before the 92% came in.
They were 90 for admitted and 95 for non-admitted. But so it's a little bit puzzling to say that the tolerances are for patients who choose to wait later or for whom there's clinical progress, because that's not actually reflected in the provisions of the direction. However, the point I will come back if we may to the regulations and the clock starts, because it is relevant to the RTT 18-week point. However, the simple point I was seeking to make is that if one looks at this, including at paragraph 6, there are a range of enforcement mechanisms which, in my submission, undercut the point that my learned friend seeks to make, which is that these target duties are vague and meaningless, because not only does one have in practice a high degree of political tolerance, one has the monthly publication of figures, and one has the guidance on the reviews needed, which if there is a falling short. And so even before, whilst my learned friend says that this state of affairs has endured for a long time, it has not endured as a result of a lack of direction or attention to attempts to rectify it. And we go back to the factual finding in relation to the reasonable efforts made by the NHS. And I won't go beyond that because even the court doesn't have further evidence on that. But in my submission, that leads, if I may, to the points I wish to make on the NHS Constitution. We've heard a great deal about the NHS Constitution and the handbook, and the learned friend has sought to rely on it as a means of saying, again, that there was a clear pledge of right, and that the construction given by the court to these obligations has watered those obligations down, set out in the handbook. I don't want to take time going again through the iterations of the right and how it developed. You've seen all the material already. But what I would respectfully point out is, firstly, that what was new in 2010, when the pledge became a right, was the remedy. What we had previously was a pledge to meet targets for consultant-led waiting lists, and you've seen that in the 2009 documentation. What happened and was clearly new in 2010 was the corresponding remedy in the event that these standards were not met. And in my respectful submission, that is in fact very carefully described in the 2010 iteration of the Constitution and Handbook. And just perhaps to turn back to it briefly, I don't want to go through the history of all of this again, but at tab 21 of the authorities bundle, the court had the handbook, and we've established already, well, there's a reference, perhaps I think the court may have been shown at page 7, which refers to the consultation. A new right to waiting times will come into effect in April 2010, so that's a reference to the directions. This handbook has been amended to explain what the new right to waiting times means. And we then go, I know my lady in court has seen this, page 20, where you have the amended version of the Constitution. You have the right to access services within maximum waiting times, or for the NHS to take all reasonable steps to offer you a range of suitable alternative providers if this is not possible. And then in my submission, that is carefully described at page 21. This is a new right. There's new legislation to support it. Back to the directions. And then from 2010, you have the right to, and then there's the provision. And that's the part that my learned friend, of course, relies upon. But we would respectfully submit that it is carefully balanced by the or. If this is not possible, the PCT or SHA, which commissions your treatment, must investigate offering you a range of suitable alternative providers that would be able to see or treat you more quickly than your original provider. So that is a careful statement of the extent of the remedy in the event that the waiting times list is not met. And it's actually quite transparent about the extent to which it is limited to the PCT or SHA commissioning your treatment, investigating, offering you a range of suitable alternative providers.
It's not limited, is it, to cases in which the 18-week standard is not met? It'd be perfectly possible for the 92% 18-week standard to be being met, but there'll be individuals who are in the 8%.
Correct.
And what the second half is doing, what Regulation 47 and following are doing, are catering for those 8%.
Well, it's catering for anyone for whom the standards are not met.
Yes.
So,
but it doesn't itself assume that the standards are not being met.
No, that's a fair point, my lord. But what it does is to confer clearly the individual remedy in the event that the waiting time limits are not being met for the individual patient.
And so if we go back to page 20,
yes,
you have the right to access services within maximum waiting times, or the or is accurate so far as the individual is concerned. It's just that those two halves do not correlate with the first half is Regulation 45 and the second half is Regulations 47 to 48. For an individual, you'll either get the benefit of being within the general duty, whether the target is met or not.
yes.
And if it is met, you may be within the 92%, but you may not.
If
you're not within it, whether it's 92% or 50%, you've got your individual rights under
yes.
Regulation 47. So it's not, as I had first thought, a dichotomy between the two different rights, expressed as it is in the Constitution.
That's correct, my lord, and I think I may have put it quite loosely, because the point is that what was new in 2010 was the individual rights. It was that there were already directions to the NHS as a whole to meet the 18-week directions, and there was a pledge that that would be the aspiration of the system as a whole in the 2009 Constitution and Handbook. But in 2010, with the directions, we had the introduction of a remedy for the individual for whom those standards were not met. And that, in a sense, as my lord is observing, is something of a freestanding duty, because it's not attached directly to the 92%. It simply attaches to the individual and whether or not the clock has started and stopped in an appropriate manner. And so I would respectfully submit, firstly, that the obligation, the 92% standard, isn't being watered down by the handbook and the Constitution, because they are attacking slightly different targets. One is, as one might anticipate, the obligation on the system as a whole to meet a standard. The other, which is the book directed, publications directed at the patient, is looking at the individual rights and the individual remedies, which are not linked in that fashion. The other point, my lady, which I would respectfully make about the way in which this ground has been framed, is that whilst it may not matter in the light of the discussion that we've just had, my learned friend submissions do stray to really resurrecting a ground that was rejected by the court below, and that was ground 3. So if the court turns to paragraph 112 onwards, ground 3 is set out. And Mr. Lockbelow submitted that the long waiting times, it was specifically in relation to the adult GID services because that was a consultant-led service, and he accepted that the rights in the Constitution were limited to those, gave breach of the duty to have regard to the right to start consultant-led treatment within 18 weeks. So there's the have regard obligation. And my learned friend really was saying, in effect, that we were out of step with the Constitution. But the key point is at paragraph 115, where in looking at the obligation on NHS England imposed by Section 2 of the 2009 Act, the court observed that the NHS Constitution refers to rights as set out in the handbook. That in turn sets out the rights found in Part 9 of the regulations. Well, the court at that point was referring to, I think, the 2012 version of the Constitution, which by then had been updated to refer to the 2012 regulations. We've just at the moment been looking at the version which refers to the directions of 2010, but the point is the same. So the NHS Constitution, he considered, does not impose duties additional to those in Part 9. It follows that if NHS England has complied with its duties under Part 9 of the regulations, breach of the duty to have regard to the NHS Constitution could not separately justify relief. My lady, it's a point framed in a slightly different way, but it's essentially the same point. The Constitution, despite the obligation to have regard to it, is expressly founded, or the rights in it are expressly founded upon the legislation which underpins it. And there's direct reference to the source of that legislation in page 21 that we just looked at, which in turn, at page 116, gives you the reference to the directions. And that same, that will take time up, but that same pattern is seen with later iterations, which in turn refer expressly, as my lord observed below, to the 2012 regulations. So one can't use the NHS Constitution and the handbook to widen or interpret, indeed, the obligations under the regulations, because that gets it back to front. The regulations are the source of the rights, and they're not a means of interpreting or widening those rights.
Conversely, if they did seem to be expressed in wider terms, they're only of any statutory effect pursuant to a have regard to duty,
yes,
which is not an achievement duty.
Which is not an achievement duty. And this case is plainly it's not a legitimate expectation case, and never could be, because the underlying basis of these rights is legislation, so it would have to give way. So there's no way in which the Constitution or the handbook can be used to reframe the rights or to construe the rights under the regulations. So, if I may, I'll try and come back to the question of where all of this takes us in terms of construing the language of the registration. There was, of course, a discussion of the nature of target duties in the judgment below, paragraphs 86 to 89, where Mr. Justice Chamberlain set out the various types of target duties. The first one that he identified at paragraph 87 was the fact that a duty could be framed in terms so open-textured that there was a broad discretion subject only to the constraints of rationality. I'm so sorry, I do apologise. I'm actually looking at, I should be looking at paragraph 89, which was the last obligation that he identified. So you've got a hierarchy in a sense. The most broad target duties identified at paragraph 87. Then we get the middle category, a duty on a proper construction requiring the person who owes it to act with a view to achieving a particular result rather than simply to achieve that result. And that's really what we're discussing here. And then the third duty was the fact that the duty could be owed to the population rather than to any individual. And that third duty, at any rate, is the starting point for this case, insofar as it is common ground that this duty is a target duty in that third sense, in that it's not directly enforceable by an individual. It's referable to a cohort whose identity will shift month by month, and it's impossible to ever identify the 8% who are within the tolerances and those who are outside the tolerances and represent the point of breach. And I think that is common ground and is the reference to Ahmed at tab 9 in the bundle, but quoted in the judgment there. So the area of debate is really the second category at tab 88, which is the obligation to achieve a particular result. And I have been submitting that the language of ensuring, making arrangements to ensure, we would submit, sits not only consistently with our commissioning obligations, but we would say reflects exactly that kind of obligation. And the case in which that was most aptly illustrated, we would suggest, was in fact the Ilya case, or the Ali case, where, and I know the court has looked at this 7 times, although I accept tab 5 of the authority bundle, although I accept that there are clearly differences in language between the section 8 duty that is set out there and is characterised as being a target duty and the one that we're looking at here, it is nevertheless of some considerable importance that what was the breach that was in issue in that case was the fact that there weren't any school places at all. So on its face, of the 400 or 500 children who were affected by the case. So whilst there is a great deal of discretion implicit in particular little b, underneath little b, the part of the provision which says that the schools available for an area shall not be deemed to be sufficient unless they're sufficient in number, character and equipment to afford for all pupils and so on. There was, in fact, at one level, a hard-edged duty or a harder duty to actually provide enough school places for a child. And that was the sort of fundamental starting point of this obligation. And it's only after you've provided enough places, as it were, that you would get onto an argument about whether or not the places that were ostensibly provided were not actually sufficient because they didn't meet the standards set out in the remainder of this particular provision. So against that background, I do say that respectfully that it is significant that the court was able to characterise or to continue to characterise this as a target duty in the context of a case where the school's places in question had not been provided at all. And so I would respectfully submit that one can have the situation of a target duty to attain a particular result across a wide category of statutory language, and that the observations of there being built into section 8 a degree of elasticity do apply with force to the situation which we are in, where we are looking at making arrangements to ensure a particular result. Then, of course, my lords, my lady have seen already the rest of the judgment, where in particular we do note, of course, the fact that even if there is a failure, although the duty, there may be the failure, there may be a situation where if a provision was not made, the authority has not complied with the standard which the section sets for a limited period is not automatically in breach, and the reference to changing situations could not be anticipated, nor questions of resources or provided. And then equally, I just note, or ask the court to note, at the bottom of page 829 H, the reference to the question of remedies, where even if you get to the point where there's a breach of a duty, the court may not intervene as a matter of discretion if, in this case, the local education authority is doing what reasonably can to remedy the situation. The situation best left in the hands of the body to which parties entrust the performance of the statutory duty. And that, of course, is a reference back to the fact that the court attached some weight to the fact that the Secretary of State had been given a power of direction under Section 68 to intervene in situations in which the standards have not been met. That wasn't, of course, a power to make regulations. That was a specific targeted directions power enabling intervention in the case of failure. And it is, therefore, directly analogous to the power that the Secretary of State possesses in this situation to give directions to NHS England if it thinks it's failing to comply. And my lady's already seen section 13ZC, I think, and the analogous power that NHS England has to make directions for ICB. So one has, as part and parcel of the judgment that the court is making here, the fact that you have an evaluative exercise in the standards that have to be met, that places their sufficiency, and secondly, relevant to the court's attitude to ostensible breach, the fact that there are political mechanisms to intervene in the case of failure. And those mechanisms exist in the situation that is before this court as well. We have, in effect...
That's my fault. I'm not really understanding that point. It's the point the judge made in paragraph 94.
Yes.
The fact that there's a power of the Secretary of State to intervene under 13ZC suggests that the legislator didn't intend the duty to be an absolute duty. But I don't quite understand why that is so. One might have a power to intervene to remedy a failure to achieve an absolute duty, just as much as a power to intervene in relation to a target duty. Why is it indicative of one rather than the other?
Yes, I think that it supports, it's probably more accurate to regard it as supporting a judgment that's already been made upon the nature of the target or the evaluative exercise that is required. If you have a duty that is encompasses a wide series of discretions and evaluative judgments and so on, then it is classically paradigmally a duty that the court would be reluctant to interfere with. By contrast, the Secretary of State is well able to make the political judgments that are necessary to decide whether or not intervention is required or not. I do accept, however, that the power of direction is a wide one, and it's not in terms allied to target duties or any other kinds of duties. It is a power to intervene when the Secretary of State thinks that things are not as they should be, in effect. But in this case, it
could include, couldn't it, a direction that the 18-week standard no longer needed to be met. It doesn't have to be a direction which imposes a greater burden. Suppose it were an absolute duty, the existence of a power in the Secretary of State to relieve from that absolute duty might be said to be consistent with and support it being absolute rather than a target duty.
Well, the approach in the Ilya case is one in which the court felt that I suppose the initial appearance of this point is that the court, Lord Justice Wolfe, makes the point that it isn't entirely for the local education authority. I'm looking at the bottom of page 828. It isn't entirely for the local education authority to decide what steps it could reasonably take. Such an approach would be inconsistent with the fact that the Secretary of State is given a power of direction, whether under section 68 or section 99. And then that is then allied to the point that is then made at the bottom of page 829, where the court says the situation is best left in the hands of the body to which Parliament has entrusted the performance of the statutory duty if they're seeking to fulfil that duty. So I do accept, my lord, I think my lord is correct to say that the fact that there are other remedies perhaps doesn't assist in the construing the nature of the duty. It is, in my respectful submission, highly pertinent.
But sorry, the reference at the bottom of 829 to the body to whom Parliament has entrusted performance of the statutory duty. It's not a reference to the Secretary of State, is it?
No, my lord, you're entirely right. I'm sorry about that. That's conceding on my part. I think it's really.
It's saying if the person who is given the task are doing their best, then it's best left to that person as the person to whom Parliament has entrusted the function.
Yes, although I would respectfully still observe that the fact that the Secretary of State is given a power of direction in situations in which there is an evaluative exercise that comprises a number of political judgments, and he would be well able to decide whether or not to intervene, is relevant to the question of relief, even if my lord's quite right to pick me up that reference doesn't appear from that point in the judgment.
Thank you.
So I would respectfully submit that if one looks at the nature of the commissioning exercise and the fact that one can have target duties in a wide variety of circumstances, I would respectfully submit, and an analysis that survives, in the case of Ilya, even the circumstances that where the court there was dealing with a complete absence to make provision at all, that goes to support the construction that was put on the language in this particular case by the court below. And my lord, we would respectfully submit that really, in a way, there's not much I can add to the issue of the construction simply by saying that it is a phrase that reflects, we would say, the wide nature of the exercise that has to be performed by commissioners when they make arrangements, and the fact that they are not ultimately responsible for the immediate delivery of the arrangements, but those have to be done by third parties who may be troubled by matters that equally well that are not in their control. And I've already made the point, my lady, that one doesn't, as a result, reach the conclusion that means the obligation has been watered down in some way. It is still very much actively enforced and considered, not least because of the guidance that requires review and response in the event that the standard is not being met. And I think set out in our skeleton argument how that is a matter that is of real important attention, this whole area, rather than something that somehow slips under the net because of the absence of, we would say, a hard-edged obligation that is enforceable by this court by way of declaration. I do respectfully pray, however, in aid the fact that, as we've already seen in the context of the discussion that was already had with the court on the 2010 changes, that there is also a remedy for individual patients, not in every case, but in circumscribed situations under regulations 47-48. So in my respectful submission, that does go hand in hand with a recognition of the limits of the duty under Regulation 45. You have an obligation to try and achieve as best as can be achieved with all the guidance that we've looked at a particular result, and in the event that it is not met, or rather in the event that the individual patient treatment has not attained those standards, there are the regulations, the remedies under Regulations 47, 48.
But it's an important distinction from the point you're making, because if Regulation 47 to 49 can be given perfectly sensible content, if it's an achievement, if Regulation 45 is an achievement duty rather than a target duty, then the existence of the 47 to 49 remedies don't tell you anything one way or another about it. In other words, Regulations 47 to 49 may be intended to cover the 8% when you're performing the Regulation 45 duty. They don't assume that you'll fail to fulfil the Regulation 45 duty, and they're there as a fallback if and when you do.
Yes, but they illustrate in my submission the fact that we're talking about a regime that has different safeguards, or a number of safeguards for the patients who are affected by it. You have the systemic duty, I would respectfully submit, at the national level to attempt to achieve a result, supported by guidance, supported by publicity, supported by all the recovery plans that the court will well know about. And then we have the individual remedies for the patients, which are quite freestanding, as we've acknowledged and discussed. And of course, although it again doesn't insist directly on the nature of the obligation, there are the residual powers of the Secretary of State to intervene one way or another in the event systemic duty is not being met. So that's, in my submission, a perfectly understandable regime that secures real results for patients, but is consistent with the nature of the commissioning obligations placed upon NHS England or ICBs, and reflects the fact that, as I've rather laboured the point already, and the court knows it well, we are not the guarantor, we are not the immediate deliverers of the right, which is delivered through third parties, through trusts, providers, and who in turn may also be affected by circumstances outside of their control. My lord, my ladies, my lady, I think that deals with the best part of what my learned friend has said. I think the other points he made were firstly that the phrase "make arrangements to ensure" appears throughout the legislation, the regulations, and in particular we looked at the NICE guidance. In my respectful submission, if one appreciates that this is not in fact a loose or vague or unimportant set of obligations, then even if one was forced to construe the obligation consistently throughout, and in my submission that's not in fact a step that this court needs to take because the circumstances of each regulation probably deserve more careful and more detailed scrutiny, then it would not follow that that amounted to a watering down of the regulations in a damaging fashion. So it's only because my learned friend is able to talk about loose obligations and failures that there's any significance to the submission that the regulations have to be read consistently whenever one gets the phrase "make arrangements to ensure." If you accept my submission that actually these regulations have real teeth and real force, even in the absence of a hard-edged obligation that my learned friends put to you, that problem is not a problem at all. But in any event, I would respectfully submit that what we haven't done is delve into, for example, what the remedies are, what the problems would be in the event that there weren't effective arrangements to secure the provision of drugs via NICE in the way that my learned friend has been putting to the court. Those are quite detailed provisions, and they come in the context of very detailed recommendations from NICE, which in effect takes over some of the commissioning responsibilities of NHS England about what decisions ought to be made about the provision of drugs. And in my submission, we don't need to go into the detail of those without the factual matrix that would enable the court to look at this in more detail. The other point that was being raised was in relation to Tandy, and I'm not sure that I can add much to the discussion that's already taken place on that case. I mean, it is clearly the case that, as a matter of fact, it related to an individual right, a right enforceable by an individual, in the same circumstances as Mr. Justice Sedley, as I think he then was in Rixon, rested his judgment upon those individual rights rather than the target duties which weren't enforceable by an individual. But I think as a result it's difficult to make much of that decision, whilst I accept that the debate about the Ali case and the importance of the foreseeable circumstances does create a further dimension to it. May I just briefly, as I'm conscious of the time and whether or not I'm actually assisting the court, just deal with the question of remedy? Because Moylan and Friends' submission is that if we're wrong about the construction that we put upon this obligation, or the court below did, and that it is in fact a hard-edged remedy, a hard-edged duty, then the remedy ought to be a declaration. As to that, firstly, I do respectfully still rely on the Ilya observation that, admittedly in the context of a target duty, but I would respectfully submit this is equally pertinent in this situation, where Lord Justice Wolfe said a local education authority which is faced with a situation where, without any fault of its part, it has not complied with the standard which the section set out for a limited period, is not automatically a breach of the section. Here I refer to changing situations that could not be anticipated, not questions of resources or priorities. Now, the fact is we haven't had the very detailed investigation of the facts as to compliance across the NHS as a whole, but to the extent that the court has information about the reasons for this difficulty, we would respectfully submit, and I made the point at the very outset, in a situation where the default is not as a result of the failure to allocate resources, priorities, and so on and so forth by the NHS, or NHS England specifically. More, or just as pertinently, we drew attention in our skeleton argument, and I'm looking at paragraph 35, I think, to the case of we drew attention to the question of what the impact of the declaration is. And whilst I know that this may be familiar to the court, we put in the authorities bundle the case of Craig and His Majesty's Advocate for the Government of the US at tab 18 of the bundle. And that's a case, of course, on the importance of declarations and the obligations to comply with them. And the relevant passages start at page 1283 onwards, where this was a case which concerned the Secretary of State's failure to comply with declarations. And at paragraph 44 is the well-known fact following M, clear expectation the executive will comply with a declaratory order, and its reliance on that, of course, the courts usually refrain from making coercive orders. And then at the very bottom of the page, citing, I think, from M, Lord Justice Wolfe saying, the very last two lines on the page, as been the position in the past, the Crown can be relied upon to cooperate fully with such declarations. And then at paragraph 46 over the page, the government's compliance with court orders, including declaratory orders, is one of the core principles of our constitution, vital to mutual trust. And then dropping down to little e, just above it, a declaratory order itself has important legal consequences. Firstly, of course, the issue which forms the subject matter of the declaration is determined and res judicata, but perhaps more pertinently in this situation, in addition, a minister who acts in disregard of the law as declared by the courts will normally be acting outside his authority as a minister and may consequently expose himself to a personal liability for wrongdoing. And of course, we would respectfully suggest that what is being said of the executive would of course apply equally to NHS England. So my concern is to flag up what the status of a declaration would be in terms of the action that it required. I suppose it goes back to the point made, or the discussion at the beginning of my submissions, where my learned friend was keen to cast this as a situation of one of resources. Well, I've already made the point that this is a case that did not start off as one about resources, and the findings in relation to some service at least clearly establish that this wasn't a resources case, or alternatively merely a suspension or a suspension. But we are not, of course, the body which would have a power to suspend the application of the regulations, to make any changes. The consequences of a declaration for NHS England of acting unlawfully would be real but uncertain. And so we do respectfully submit that this is one of those rare cases in which...
If the court's decision is that it's an absolute duty, which despite having taken all reasonable steps, it isn't good enough, the court's going to say so. Does it matter from the point of view of knowledge of whether you are acting or not acting unlawfully, that there's declaratory relief granted or not granted?
No, I mean, it's a difficult point, my lord, and I fully appreciate what my lord has said. We are concerned, I think, to anticipate further litigation, or rather the prospect of further litigation. My learned friend says at the moment that declaratory relief is all he seeks, but we don't know what happens in the event that the court makes a finding, makes a declaration, and matters then proceed.
Well, that's as maybe, but that's the problem you face, whether or not there's a formal declaration at the end of the judgment which says, on this hypothesis,
yes,
this is an absolute duty.
I suppose that what we're trying to anticipate or trying to suggest is that the court itself, by highlighting as well the fact that we are, on the findings of the court below, taking more reasonable steps to meet this duty, at least signals that the answer is not a simple question of finding more resources somehow to meet it, that there are complicated evaluative decisions and exercises which stand in the way of a simple translation of the court's judgment into immediate forms of action, which at least would give us some comfort against the observations I've just drawn your court's attention to on the effects of declaratory relief. I can't put it any better than that, my lord. I know that doesn't sound very satisfactory. It's a difficulty which arises from the clash of a situation where, on the applicant's case, this is a hard-edged duty to achieve a particular result, and our observations founded upon the judgment below that we're already doing everything we can to achieve that result.
The judge's reasoning, which he used to support, indeed as he thought, the main reason for his construction, as opposed to simply whether there should be a declaration, was, as I understand it, that because the purpose of a declaration would be to encourage some particular activity on the part of NHSE, it wouldn't be appropriate where they were doing all that they could and there was no further activity which needed to be encouraged. But speaking for myself, although of course I understand the authorities say usually order a declaration, but you don't have to. But if the decision of the court were that this is what it means, it's an absolute duty, I don't see why the court shouldn't declare that that is. In fact, it's going to say so in a reasoned judgment. And the effective declaration is, as Lord Reed says, that becomes a matter of res judicata, so
Yes.
that everybody can take advantage of it.
I understand entirely the point that's being made by my lord. The question we have is, what do we do as a result of a judgment or a declaration, I suppose? And I suppose the question is whether or not the decision by the court that declaratory relief would not be appropriate in circumstances when the body was already doing everything it could, would in some sense signal or underline the fact that this would create, or that the situation which we are is an impossible conundrum, and requires further thought, further consultation, and further action. My lord is entirely right that once the court's judgment has said X, then X follows, whether or not there is formal declaratory relief or not. The question is whether or not there is any assistance that the court can give to square the impossible circle that will arise in the event that the appellants are right in their construction of these regulations. I don't think I can put the point any better than that.
And do you want to say anything further in support of the judge's reasoning in paragraph 95 that this is an aid to construction? I quite understand that if your argument is if it is an absolute duty, there is a conundrum, not just going forward, but would indeed have been a conundrum in order to be able to comply with it, and that itself is a reason for your arguments on construction. But the mere fact that if you're subjected to a declaration as opposed just to a reasoned judgment, you will face a conundrum. Why is that a matter of assistance on construction, which seems to be what the judge was saying at paragraph 95?
Well, I don't think it was as narrow as a point about the declaration per se. It was a wider point about what they thought should happen as a result of a judgment in their favour. So, in particular, the skeleton argument that is quoted at paragraph 96, where the claimants set out in their skeleton the fact that we have many calls on our budget, a discretion to decide how much to focus on our directly commissioned services, then a declaration of the important point of marking, etc., ensuring that future budget allocations will be sufficient to fund services to meet NHS legal duty, etc. And what happens at paragraph 97 is that he took that to mean, I think correctly so, in the light of argument, because this was developed in argument and was said quite expressly, that NHS England's options included retaining more money for its specialised services function and withholding money from the ICBs, despite the fact that they, of course, were subject to exactly the same duties. And it was that which the court was concerned about. And I think that goes perhaps more directly to the whole question of the evaluative exercise, which we do say is implicit in the commissioning function, which wraps up a whole number of considerations, including the one as to the attainment of standards, and the fact that although it may not be immediately apparent from the language of the regulations, there is an evaluative exercise akin to the target duty cases that we've been looking at, encapsulated in those obligations. So it may not be apparent on the face of the language very clearly, but it's when one analyses what we mean by commissioning and therefore the language of arrangements. And that, I think, is what lies behind the judgment at that point. And it's clearer if one understood the argument, where this, the oral argument below, where this was much more directly counted.
Thank you.
I think that's all I can usefully say about the first point. If I can just very briefly deal with the consultant-led services.
Yeah. Respondents, your respondents' notice.
It's my respondent's notice,
Yes.
my lady, and it comes in the context, or what I will say, I think, has already been helpfully circumscribed by, firstly, the fact that my learned friend has already taken you through the sort of progression of the obligations, but also his express concession that if you look at all the material that has been relied upon as an aid to at least setting out the background, and we would therefore say as an aid to construction of the regulations, it speaks with one voice. There was an intention to, first of all, create pledges with regards to waiting list times for consultant-led services, and I am using that term to include the complex subject of interface services. And then that was widened, or an additional right was added in 2010 in relation to remedies, but that too was limited to consultant-led services. And that when one got to the 2012 regulations, whether you look at the underlying material in the explanatory memorandum, which says in terms that nothing new has been created, and we looked at that, or whether one looks at the RTT rules suites in their 2010, their 2012, their 2015 iterations, it's quite plain that the Department of Health, NHS England as such, took the view that the rights that were being conferred and the rights that were encompassed in regulations 45 to 47 ultimately related to consultant-led services. It is, I think, conceded by the learned friend that there is nothing else to suggest any intention to change that. And we've looked in relation to the 2010 directions to that table which refers back to, it's a performance framework which I haven't burdened the court with, but that in turn is based on the operating framework for 2009 to 10, which is in the bundle, which in terms gives the standards that are set out as percentages as referable to consultant-led services. That's where it comes from in 2010. It then moves on in 2012 and it refers only to consultant-led services. So I don't want to take the court back to all that underlying material. Your Ladyship, the court has it. But it demonstrates very clearly in my submission that there simply was no intention, no statutory intention, to widen the rights in the 2012 regulations to encompass all referrals to healthcare services, rather than those merely to consultant-led services. But what's said against me is, in effect, well, that's all very well, but if you actually look at the language of the regulations, it's very clear, and therefore you can't create some, you can't recast them to achieve a different result. As to that, firstly, I think my Lord already has the point that the mechanism that we've suggested, the hard stop in Regulation 44, would have the requisite or the desired effect to align it with the statutory intention. Because once you've redefined and clearly defined eligible referrer as meaning only somebody who refers to a consultant or a member of a consultant's team or so on, then what you achieve is a narrowing of the obligation in Regulation 44.
Because you don't get a start date.
Because you don't get a start date, exactly.
The referral to the health service provider is from an eligible referrer or the person with the approval of the eligible referrer.
That's absolutely right, my Lord. I'm grateful. It's because of the effect of Regulation 46. So it works as a piece of drafting. It corresponds, I would respectfully submit, to the intention, because we know that from all the material we've looked at. And what's said against me is, well, it's a nonsense to do this when in particular it would render parts of Regulation 47 odious. I think that's probably the most accurate way of putting it.
Well, before you get there,
Yep.
it said it would render A, B and C odious. Because if it meant, if the whole of eligible referrer was any person whose request to refer is accepted by a consultant team, you wouldn't need to identify GPs, general dental practitioners, or people who are specifically identified as able to make that referral. It just renders all that language unnecessary.
I fully accept that this is not how one would choose to draft this. It's not a well-drafted provision. The reason why the definition is in that form is probably because it's been lifted but relocated from the 2010 directions, where it first makes its appearance in what is now Regulations 47, 40 to 48. So at that point it made some sense, because if we go back to those directions,
Just remind me where it is.
it's tab 22, and at direction 2 on the second page we have the strategic duty, if I can call it that, which is drafted in what I would call NHS speak rather than statutory language. It refers to, for example, Annex 1 of a performance framework, and then there's a footnote to the actual source of the obligation, which now, of course, is broken. So it's very much the language of operational obligations rather than the sort of statutory language that we'd normally see. And then we get the definitions that follow up paragraph direction 3, and one can see there the direction defining an eligible referrer: a general dental practitioner, general medical practitioner, and any other person whose request to refer is accepted by the person following between paragraph 3A. So that is in effect the definition, and I accept that it is in effect in terms the same as that which is then lifted across to the definitions section at Regulation 44 in Regulation 2. But of course the problem is that at this stage we know that Regulation 3, Direction 3 is well drafted, because it says in terms at subsection 3, the referral for assessment or treatment of the course of provision service under that section by a consultant, a member of the consultant's team, etc. And that, of course, is then imported into Regulation 47. So we've got a situation in which a part of the definition that only referred to the remedies under paragraph direction 3 and 4 is translated across to Regulation 44 in the 2012 directions, and I'm using it, as I freely accept, as a mechanism to attempt to redefine or rewrite, rectify the regulations to reflect what is the clear statutory intention. And I accept that it has the consequence that the provisions in Regulation 47 would be odious, but there are also, I would respectfully submit, difficulties with the learned friends approach as well. Because if we look at the definition of the start and stop dates, going back to the 2012 regulations, and look at, if we may, at Regulation 46, I'm back looking at the 2012 regulations, my lady. We know that this waiting time starts as described, begins with the start date, ends when any of the following paragraphs apply. Firstly, the referred person received appropriate treatment. Well, appropriate treatment is defined at Regulation 44. It means treatment that is the first treatment provided to a person as a result of and in response to an elective referral. So that's a situation where you get your treatment, clock stops. But then there's a further provision. The referred person commenced therapy or received a healthcare science intervention where a consultant, a member of a consultant-led team or an individual providing an interface service decides that the therapy or the intervention is the treatment that is most appropriate for that person. So there is therapy, and if we go to the definition of treatment, because we've looked at appropriate treatment, but treatment is also defined at Regulation 44. Treatment means an intervention that is intended to manage a person's disease, condition or injury, and insofar as reasonably practical, avoid further intervention, but does not include a therapy or healthcare intervention referred to in Regulation 46.3. So treatment doesn't include therapy, and therapy apparently only applies to therapy offered by consultant-led teams. And the question that I rhetorically pose is, given that the thrust of my learned friend's submission here is that the cohort under Regulations 44 to 45 is the entirety of referrals, including from primary care service to primary care services, and below we discussed the example of physiotherapy, for example, as being one instance where, on my learned friend's approach, physiotherapy referrals are encompassed in this. Then where does that fit? Because on its face, physiotherapy is a therapy. It's not an appropriate treatment. It's a therapy, and the same could be said of cognitive behavioural therapy in references to mental health therapy. The natural place for them is under Regulation 46.3, but only if they are being provided as part of a consultant-led team. So in order to bring therapies into this regime, such as physiotherapy, the court has to decide that they can be encompassed under Regulation 46.2, and the start of physiotherapy constitutes instead the receipt of appropriate treatment. Otherwise, if you're dealing with physiotherapy, you've got no home for it, because you can't fit it under 46.3 because it won't be provided as part of a consultant-led team. And the same would apply to, say, cognitive behavioural therapy provided as part of a mental health trust that wasn't consultant-led. Now, I appreciate that this all sounds rather bizarre and obscure, but the point I make is that if it's said against me that the regulation provisions under Regulation 47.3 would become odious, the same applies. There are also difficulties in the approach adopted by my learned friend, because we can't give, I would respectfully submit, any proper or sensible effect to the provisions in Regulation 46.2 and 3 in the case of therapies that are basically primary care therapies or mental health therapies. You either have to redefine them as actually being treatment, in which case you have no content for Regulation 46.3. So it isn't a simple situation of simply being able to say, well, these regulations work as a scheme and they don't need rectification because despite the quarrel with all the underlying material, they seem perfectly clear on their face. There are difficulties in interpreting them on their face if one takes the approach of my learned friend that any form of elective referral, whether to primary or secondary care, is encompassed in Regulation 46.1. So I would respectfully suggest that there is a real difficulty with making these regulations work in the fashion intended. If the learned friend is right in saying that there was an intention to widen the eligible cohort. The second point I would make about that in relation...
I was just turning my fault. Slow. So it is essentially the point that therapies under 46.3 don't stop the clock unless they are consultant referred.
Yes.
That's the short point.
Yes, that's the short point. And so if you, if they're delivered as part of a consultant-led team, so if you're referred for physiotherapy, if you accept it's a therapy, and cognitive behavioural therapy would be another example. And remembering, of course, that mental health trusts are not part of interface services, or often not delivered as part of consultant-led services either. We have exactly the same problem with them. So there's no stop date for therapies, in effect, unless one goes back to the solution of finding that the cohort was intended to be circumscribed so that the regulation 44-45 cohort is the same as the regulation 47-48 cohort. If I may, in relation to the theoretical justification for narrowing the regulation 47-48 cohort that Moylan and friend put forward in relation to patient information and patient rights, I would just make 2 points. The one is that, as he acknowledged, that is an ex post facto rationale, which may have some, it's been put forward as having some theoretical advantages, but it's not in any way founded upon any form of statutory material suggesting that that was actually the intention. It is a wholly theoretical justification. And as a theoretical justification, I would respectfully suggest it doesn't pass muster. It makes no sense to say, well, we don't have information about the wider cohort at the point when we are first referred, but that's a reason for limiting our remedies under section 47-48. There's a parity of problem at either stage, whether you're having your first referral from your GP to physiotherapists, or whether you're trying to exercise your right of appeal. In neither event do you have the wider information that is encompassed by Part 8. And so in my submission, it makes little sense to put all the emphasis on how important it is to have that right as a reason for narrowing the section 47-48 cohort, when the problem has been consistent throughout and applied to that wider cohort at stage 1 as well as stage 2. I hope that makes sense. Sorry, it's becoming late. The other point I would simply make in relation to this argument, and it goes to a point made by the learned judge below when dealing with this issue. He observed that Miss Gray was unable to point to anything that encapsulated the rationale for limiting the rights under Regulation 44-45 to the narrower cohort. I'm sure the fault was entirely mine. This was paragraph 71 of the judgment. Ms. Gray could not explain the rationale for excluding from the duty in Regulation 45 referrals to services that were not consultant-led. She could find no document showing a drafting intention behind Regulation 45, and then he went on to say that there was no necessary inconsistency between having a wider cohort in Regulation 45 and then a narrower cohort in Regulation 47. Well, the fault was of course mine, but there is some material in fact. If we go to tab 24 of the bundle, and to the, this is the authorities bundle, and look at the referral to treatment consultant-led waiting times. So sorry, that's the wrong reference. It's tab 25. It's the rules suite. This is the detailed guidance that it's set alongside the regulations, and we haven't really looked at it in detail, although there are points sidelined. But my learned friend has, of course, already accepted that it's of one force in assuming that the obligations only apply to consultant-led services, even at the stage of regulations 44 to 45. But if the court would be kind enough to look at paragraph 15, page 15, internal numbering, there's a discussion continuing here about interface services. And we're told that interface services don't include non-medical consultant-led mental health services or referrals to practitioners with a special interest, except when in effect they're working as part of a consultant-led team. And so much mental health activity will be outside the scope of consultant-led waiting time. And then there's an exception if the mental health service is consultant-led. And then if we turn over the page, it says, as noted above, decisions must be taken locally about whether a particular service model falls within the definition of an interface service or not. Recognise it's a finely balanced judgment, particularly when deciding if a practitioner with a special interest is working as part of a wider interface service type arrangement or not. Referrals to individual persons with a special interest are excluded from consultant-led waiting times for two reasons. A, to recognise that measuring clock starts for referrals to persons with special interest would be prohibitively difficult and expensive to implement. And B, to avoid extending the scope of consultant-led waiting times into the delivery of primary care services. So there we do have a very clear statement of the proposition that it would be difficult to extend these rights, firstly to particular practitioners with special interest, but also generally that there was no desire to extend these rights into primary care services. Now, that in my submission is a fairly clear statement of the legislation's intention not to create a wider cohort that would encompass primary care services. That is one of the problems of the interpretation that has been endorsed by the court below.
But you've got to have an eligible referrer.
Yes.
It's that.
Well, an eligible referrer in this approach, the approach we contend is wrong, can include is a GP. So a GP can refer to a physiotherapist or a community mental health trust, for example, a local CAMS service under the control, for example, of a psychologist or even a registered mental health nurse. All of those are referrals for non-urgent treatment. And there is no limit in the approach that's being contended for in regulations 44 to 45 to say that that isn't what was intended. That's what I understand to be the effect of the interpretation that's been adopted.
But I'm just trying to get at what's meant by primary care services in page 16.
Well, primary care services are defined under the Act, in fact, but they are distinct from primary and community care services can encompass a wide variety of arrangements made in the community. I've referred to community mental health trusts, district nursing teams, physiotherapy services, audiology services. I'm sure those behind me could give more examples. Pharmacy, ophthalmology, they're all primary care services. So there is a suite of primary care services that, unless you put the consultant-led and interface restriction in somehow, could be the subject of referrals. Referrals could be made by eligible referrals.
But the judge's question, to which he wanted an answer, was why is there some reason the 18-week standard shouldn't apply to those?
Well, I think that you get it in the answer to the person with special interest, complex and difficult and expensive. I mean, it's essentially saying we have worked our way and we've gone through some of the history up to a pledge initially and then a right to have an 18-week limit for consultant-led services, interface services. We have not extended that obligation to primary care services or even more difficult services that stand at the interface between more specialised services. Now, of course, one could, in another world, decide that was very desirable, and perhaps that's all that the judge is getting at. But there is evidence, I would respectfully suggest, of a positive policy choice not to go that far. And that is really what we're seeing.
Well, you would say that all the surrounding material confirms that to be the case, and this is but one more example. The difficulty is the wording of the regulation itself, which doesn't seem to reflect the policy, as you say
it is a more direct observation on the reasons behind the policy than the other material that we've looked at. But yes, it's all of a piece, my lady, I agree. And the question is whether or not, against that background, this court feels that the criteria in Inca Europe have been fulfilled. That was tab 7 of the bundle, it is tab 7 of the bundle, the authorities bundle. And we know that there are difficulties or obstacles to be surmounted in doing that. But firstly, if I may, just turning to that briefly at page 592, the judge there refers to D, Lord Nichols refers at D to Cross's statutory interpretation.
Sorry, what page are we on?
Page 592, my lady, tab 7. And letter D there. So we have Professor Cross omitting or inserting words. The judge is not really engaged in a hypothetical reconstruction of the intentions of the draft or the legislature, but is simply making as much sense as he can of the text, the statutory provision, read in its appropriate context, and that's of course why we've been looking at all this underlying material, within the limits of the judicial role. And then power confined to plain cases of drafting mistakes, and a observation about the court's constitutional role. So before interpreting a statute in this way, the court must be abundantly sure of 3 matters. 1, the intended purpose of the statute or provision in question. Well, with respect, I would say there is very little difference, there is very little dispute on that. We know what the intended purpose of this legislation was, and it was limited to in granting rights in the context of consultant-led services. Then, by inadvertence, the draftsman of Parliament failed to give effect to that provision. Well, that really follows, doesn't it, from knowing what the purpose is and then looking at the regulations and saying it didn't manage to give that effect. And then the substance of the provision Parliament would have made, although not necessarily the precise words that Parliament would have used, had the error in the bill been noted. And that again really follows in this case from the fact that we are clear what the intended purpose was. In my respectful submission, this isn't a case where the court would be straying into areas where it would be indulging in judicial legislation, because all the material is singing with one voice. We're not really speculating about what the purpose was. We know that it was. The question is why, in a sense, it wasn't achieved or achieved better. But I've tried to suggest that there are difficulties even with what was achieved that suggest that some form of judicial intervention is required, because otherwise we've got problems in dealing with matters such as therapies. I think we made the point in our skeleton that the threshold might be a little lower in the case of regulations that INCA Europe applies to regulations as it does to primary legislation, but the threshold may actually be a little less high in the case of regulations where you're dealing with something that was passed in the case of Part 9 by negative resolution, and so didn't have the parliamentary scrutiny that would have been the case with primary legislation. So, my lady, when one looks at the way in which the material sings with one voice, the fact that even as they stand, there are problems in adopting and construing these regulations, I would respectfully suggest that however clumsy my attempted hard stop solution is, it doesn't amount to judicial legislation because the court could be confident that it actually gives effect to all the material that you've seen, including the most recent rules suite, which is 2015, which is in the bundle, which would do no more than to achieve consistency with what was plainly intended by the drafters. May I just turn my back for a moment? Unless I can assist the court.
Thank you very much, Ms. Gresham.
Can I ask a very direct question, my lady? How long have I got to play with?
Maximum 20 minutes.
That's what I was hoping the answer would be, as opposed to
Ideally
5.
10, but I'm a realist.
Let me... Very wise. Let me start with the respondent's notice. First of all, the test in INCO that we've just been looking at. The critical obstacle my learned friend faces is the third limb, the substance of the provision that Parliament would have made, although not necessarily the precise words Parliament would have used had the error in the bill been noticed. It's that, in conjunction with the first condition, the intended purpose, that is the problem. Now, there's much about my learned friend's submissions that will be redolent of a case I argued before my lady just before Christmas, the case of Kays. Do you remember the Cowser case? Almost identical. The Secretary of State thought her legislation meant one thing. She implemented that for 8 years until it became apparent before the court that properly construed, her legislation meant something else. What did the Secretary of State do in the Kays case in response to the earlier Cowser case? She changed the law. She made the regulations, which were the subject of the dispute about the impact assessment that then came before the court. The situation is no different here. The proper response, if the Secretary of State has chosen words that are objectively clear, that don't do what she or he intended to do, is to make an amendment. And if that argument is true generally, it's particularly true of delegated legislation or statutory instruments. And it must be particularly true where what one cannot identify with any simplicity or precision is the nature of the amendment to be made. One only thinks momentarily about the debates we've had about hard stops and the definitions of eligible referrers, the tautology or surplusage that then creates in Regulation 47, which has a two-step test. The reference has to be from an eligible referrer, and then it has to be a consultant-led team, a two-stage test that's rendered completely superfluous by the learned friend's analysis of the definition of eligible referrers. And the violence that is done to that definition, and it would require considerable rewriting, and even then doesn't really get at the real problem being who is it that the reference is made to, not who is eligible to refer, to realise that we are in exactly the terrain of impermissible judicial legislation or rewriting of statutes that INCO is meant to set one's face against. And in that connection, I think it's well worth having in mind the cautionary words of the Court of Appeal in the case my learned friend has rightly referred to you, the case of D, which is at tab 10 of the bundle. It's my learned friend's case. She didn't open it to you, but let me show you its relevant passage. The relevant passage, tab 10, page 44, is on the use of explanatory memoranda and explanatory notes. And what Lord Justice Carnwath, as he then was, effectively said, summarising much jurisprudence, is that you can draw upon materials as to intention where the statutory language is ambiguous. But what you can't do is effectively fashion an ambiguity using the intention and then say, aha, that is what it must mean. So much is apparent, in particular, from the passage at 45, 47, which emphasises that the purpose of this exercise is to find the intention expressed by the words used. 48, the orthodox position expressed by Lord Hope in the case of Coventry, only where there's ambiguity. And 49 and 50 extending that approach to statutory instruments. So that's the basic problem. You're being invited by a series of extraneous materials to fashion an ambiguity which doesn't exist, the reasons the learned judge gave on the face of the relevant provisions, and then say, aha, well, you must now rewrite this to reflect the intention in question. Now, the nearest my learned friend got to some kind of ambiguity were her arguments about Regulation 46 and the stop dates. But with respect to her, I'm afraid those arguments don't work. The plain purpose behind Regulation 46.3 is to provide for a situation where there is a referral to a consultant-led team. But the consultant-led team decides that treatment by the consultant-led team is not in fact the treatment that the patient requires. So instead of surgery by a back surgeon, the surgeon says, well, actually, the appropriate therapy in this case is that you have physiotherapy. And effectively, you're transferred away from one discipline to another. That doesn't stop the fact that the treatment by the physiotherapist in question itself generates another stop date under the regulations. The most obvious stop date is you go and get your physiotherapy. You've received, under 46.2, appropriate treatment. Appropriate treatment is defined extremely widely and is more than capable of embracing the provision of physiotherapy. Appropriate treatment is back at 44. It means the treatment that is the first treatment provided to a person as a result of and in response to an elective referral. So there is no lacuna, there is no ambiguity. It's just that this particular stop date doesn't work in these circumstances for a perfectly sensible reason, because the real situation is that you've been passed from one form of treatment to another, and then you need to see whether or not that form of treatment, viz. Therapy.
But isn't that carved out of the definition of treatment by 46.3? Treatment in 44 is intervention intended to manage a person's disease, etc., etc.
Yes.
It does not include a therapy referred to in 46.3. And 46.3 is a consultant-referred therapy.
And I think the answer to that is it nevertheless may be treated as being an appropriate treatment.
If it's not a treatment, can it be an appropriate treatment? No. Because appropriate treatment is defined by reference to a treatment.
Yes, you're right.
Treatment doesn't include therapy.
Well, the point, if there is a point there, and a gap in relation to therapy or physiotherapy or a matter of that kind, only extends in relation to those types of treatment. It certainly doesn't extend to the types of circumstance we're dealing with, where I don't think on any view the services provided under paragraph 46 could amount to appropriate treatment. With respect, all of this illustrates the following point, which is, as my learned friend said, these regulations are extremely badly drafted. They are. One only needs to look at the consequences of her arguments for regulation 47.2 and 47.3 to see that. The appropriate response isn't the court engaging in some kind of extensive saving exercise of recasting and filling all the lacuna, etc. It's to say, this is the meaning that attaches to the regulations, the meaning identified by the judge. If you don't like it, amend the regulations. make the appropriate changes. So that's what we wanted to say in relation to the respondent's notice. Let me make a few more substantive points in relation to the main point before you, my case. Now, it's said somehow, as an opening remark, that we've moved this case on to being about questions about resource when that was never the issue before the learned judge, and we were never making complaints about resource. To which I would respond, the reason why resource has become front and centre of consideration is the passages in the judgment that use the resource implications of the hard-edged duty found as a basis for saying it can't be a hard-edged duty, it must be a target duty. So it's not us, it's him. I think it's the response to that. And it's a peculiar argument for this reason, because when one actually follows through the reasoning of the judge in relation to resource implication, the resource implication is set up in general terms, and then it's taken through by reference to the resource implication for the treatment of these particular conditions. And we go through the detail of what's happening at the Tavistock, the problems with staffing, what my learned friend called all the capacity issues. And yet the judge himself has already made the point that the cohort is a general cohort. It's by reference to all conditions being treated. It could be discharged even if no one was receiving treatment within 18 weeks for this particular set of conditions. So that seems to be entirely irrelevant. It's difficult to then see how the logic of his resource implication concerns justifies a focus in particular on the difficulties in relation to the treatment of gender identity, dysphoria, etc. So that's the first thing we say. The second thing we say in relation to the language, and it really comes down to this question, where are we on the spectrum of hard-edged to open-textured? It really comes down, actually, ultimately, to my Lord Justice Popplewell's point as to whether or not the word to, make arrangements to ensure, is somehow pregnant with some qualification in the way that the judge has suggested it is, because he reads to as with a view to. And yet we know from the other provisions in the regulations that when the drafter of these regulations wishes to unpack qualificatory language, the draft person does so. And part 3 is full of those reasonable views of what is necessary to, etc. So there's no basis to unpack or read into Regulation 45 a with a view to type consideration. And absent that, the relevant language is the language of concrete obligation. Let me give you a contractual analogy, always dangerous. My lord sitting in the wings to shoot me down. But if the contract said, you will enter into subcontracting arrangements that will have the result of doing X, Y, and Z, you wouldn't read the contract as saying, well, actually, it's only an obligation to enter into subcontracting arrangements with a view to doing X, Y, and Z. You would be in breach if the subcontracting arrangements you entered into didn't deliver the thing that was the end target obligation. This provision does exactly that. It may be uncomfortable for the Secretary of State that it does that, but that is what it does. And if the Secretary of State and NHS England don't like it, they should change it. Then it was suggested section 6E8 and the prohibition upon making regulations directed at individual ICBs somehow precluded modification to address things like strikes and things like that. With the best will in the world, I simply didn't understand that submission. There is literally nothing to stop the Secretary of State making a generic provision saying that in the case of a strike, should any ICB be affected by as X, Y, and Z consequence will happen. The prohibition in 6E8 is simply a prohibition against making a regulation targeted at one or a number of ICBs as opposed to the cohort of ICBs as a whole. It effectively requires the regulations to address generically all of the relevant bodies. It doesn't stop the Secretary of State devising exceptions by reference to circumstances any one of those ICBs may experience. Then, in relation to commissioning, it was suggested that this somehow goes against the grain of commissioning to read the duties in this way. And one has to ask this basic question: if that is so, how is it that it's consistent with the grain of the commissioning arrangements that this position of default has persisted for over 7 years? How is that consistent with an obligation through commissioning arrangements to ensure a service standard is met? We don't think the answer to that is obvious, nor is it obvious how so diluted one is left with a right in the sense meant by the NHS Constitution. Then it was said, well, this is a matter treated as of the highest importance at the political levels. We're on it, effectively. The government's on it. I'm sure that's true, but there is literally not a scrap of evidence in any of the witness statements detailing that or addressing that. The witness statements all address the situation in relation to the treatment of the conditions of the appellants rather than the generic waiting lists in the NHS. Indeed, it was on the basis that there was no such evidence before the court that the judge refused permission in relation to ground 2.
Well, that's a lacuna in your evidence. The whole thing went off on the basis that all the evidence you put in support of a case that there was a failure to take reasonable steps in relation to GI services was nothing to the point once it's recognised that the cohort is wider, and that there's no evidence, essentially, as I understand it, before the judge, and there's none before us as to steps in relation to the cohort as a whole, and that's because there is no allegation of a failure on the part of the Secretary of State to fail to meet a target duty if it's a target duty.
Absolutely, my lord. The only point I'm seeking to make is that that point cuts both ways. And my learned friend can't point to evidence that isn't before the court to say all of this is under consideration. There's simply no evidence, for whatever reason, on that subject, one way or the other. Next, it was suggested, now this, I think, probably does require some further investigation. It was suggested that the portion of the directions that dealt with the 18-week time limit represented only the most recent incidents of earlier directions that had been made to like effect. I don't think we'd heard that before, and I don't know which directions my learned friend was referring to. She was suggesting that all that was new of the two parts was the individual remedy of choice to move provider in the event that you individually hadn't received treatment within 18 weeks. Of course, if there were directions preceding the 2010 regulations, they should be put before the court, but we're certainly not aware of them. Then it was suggested that we were resurrecting ground 3, the reference to a breach of Section 2 and the have regard obligations in the Health Act 2009. That's not true at all. The argument we make is about the construction of the 2012 regulations and the construction of Regulation 45.3. The simple point we make is that the context in which those regulations is adopted and the purpose for which they are adopted, namely to give effect to the NHS Constitution and the rights it is publicly advertising it contains, are part of the context for properly construing the content of those regulations. We agree, everything comes back to the regulations. They are the source of the rights, as my learned friend, but the legislative context helps understand what the duty in question is. Then we came on to the case of Ali, and it was suggested that the case was somehow a case in my learned friend's favour because, notwithstanding the extremity of the facts, somebody hadn't received education for a number of years, there was no finding of breach. I'm afraid that is a misreading of the case and its procedural background. Because what happened in Ali was that after permission was granted, very shortly after, you can see the procedural chronology at page 824. After permission was granted on the 19th of September 1989, one of the key claimants obtained a place and his claim turned into a claim for damages. And after that, the IEA made an application which was granted by Mr. Justice Simon Bann, as he then was, that 3 preliminary issues be tried. So there was no finding at all on the relevant question of breach. In fact, all that happened was that issue 3, the jurisdictional bar argument to which I referred to you, was tried out. And it was in answering that jurisdictional bar question that Lord Justice Wolfe identified at the foot of 825 4 issues that needed to be answered in order to answer the jurisdictional bar question. And so what was never decided in the case, in the way that it was, by contrast, in the family planning case, is whether or not the failure to provide a school place for X number of days, etc., was a breach of the relevant scheme or target duty. Simply didn't get to that because it was about a jurisdictional bar, and the argument was predicated in order to get there on the nature of the duty. And you see that in particular at 836 at letter D,
Yes.
under the heading of the discretion question. Then 2 last points, if you'll indulge me. There was much argument about section 13ZE and paragraph 94 of the judgment. The basic point we make is that that passage in the judgment actually misses the point that the regulations supplant and replace the function formerly performed by directions, and their purpose is to give flesh to the target duty in the Act. Regulations under 13ZE by the Secretary of State, directions under 13ZE, can only be made to NHS England, directing it to do certain things. They can't be made to ICBs.
Is there not an equivalent position?
No, the equivalent provision at the end of tab 1 is the power to give directions in NHS England to ICBs. It's 147Z61. So 14ZC, Secretary of State may give NHS England directions as to the exercise of any of its functions, and NHS England may give directions to ICBs. And that, as we understand it, reflects the more limited power of direction than previously persisted. Why is it more limited? Because the Secretary of State instead has the power under section 6E to make regulations, to make standing rules, which have much the same effect as the old directions used to have. So, lastly, the submission that there is real teeth in all of this. It's a point my learned friend made repeatedly, but with great respect to her and to her clients, it's very difficult to see a single denture, let alone a full set of teeth, in relation to a situation where these duties have been in a non-compliant standard.
I think we have your point on that.
I'll be quiet and sit down.
Thank you very much indeed. Well, thank you all very much indeed. I'm very grateful. We are very grateful for the detailed submissions in this difficult case, which is of, whilst very wide in its reach so far as the actual regulation is concerned, and my lords are acutely conscious of the considerable importance on a more personal level for the individuals who brought the original litigation. You will receive a draft judgment in the normal way. We can't promise exactly when that will be, but we would hope, but not promise, that it would be before the end of term. Please, both of you, explain with considerable care to your teams the nature of the embargo. Ensure that will appear at the top of the draft, that we are given the names of all those who are going to have access to that draft, and that those people that would have liked to have seen it but are not entitled to see it before it becomes a perfected judgment understand why that is, and that they will, of course, in due course, see the final version. Everything else, I hope, in written form. I hope you'd agree in order. If you can't, then written submissions only, please. Typographical, grammatical, minor infelicities, not an opportunity to re-argue, please. Thank you.
Lady, can I just check, does the court want a copy of the 2010 Constitution?
I think so, yes, please. Yes, please, we would. Thank you for remembering that. And thank you for all those behind you that have been preparation of